Justice isn't always blind, but sometimes it needs a teacher. The courtroom was polished and austere. Morning light streamed through tall windows, illuminating dust particles in the air. Judge Michael Harrison, a 42-year-old white man with a stern demeanor, presided over the bench with an air of authority. The court was in session, processing routine traffic violations with mechanical efficiency. Next case, Judge Harrison called out, barely looking up from his paperwork. The bailiff, a man in his 50s with a military-like posture, stepped forward. Case number 347B, Dr. Eleanor Washington, charged with failure to stop at a designated stop sign. Dr. Eleanor Washington approached the defendant's table. At 57, she carried herself with quiet dignity. Her dark skin contrasted with her silver-streaked hair, which was pulled back in a neat bun. She wore a simple but elegant navy suit and carried a worn leather briefcase. Her posture was confident but not confrontational. Dr. Washington, you've been charged with failing to stop at a designated stop sign on Maple Street, Judge Harrison stated, still shuffling through papers. How do you plead? Not guilty, Your Honor, Dr. Washington replied, her voice clear and measured. Judge Harrison finally looked up, slightly annoyed at the prospect of a contested traffic violation that would consume more of his busy morning. The officer's report states that you rolled through the intersection without coming to a complete stop, he said with a hint of impatience. Officer Davis has served on the force for 12 years with an exemplary record. I understand, Your Honor, Dr. Washington responded, but I must respectfully disagree with the officer's assessment. I came to a full and complete stop at that intersection. I'm very aware of that particular stop sign as I drive through that neighborhood daily on my commute to the university. Judge Harrison leaned forward, his eyes narrowing slightly. There was something familiar about this woman, but he couldn't quite place it. He'd seen too many faces come through his courtroom over the years. Dr. Washington, are you suggesting that Officer Davis fabricated his report? He asked, his tone growing colder. The courtroom fell silent. The few people scattered throughout the gallery seemed to lean forward, sensing the rising tension. Not at all, Your Honor, Dr. Washington replied calmly. I'm suggesting that from his position, perhaps he didn't have a clear line of sight. The stop sign at Maple and Oakwood is partially obscured by the large elm tree on the northeast corner, especially in the morning when this occurred. Judge Harrison frowned. He knew that intersection well. It was near his own neighborhood, and he'd driven through it countless times. The woman was right about the elm tree, but he wasn't about to admit that. Dr. Washington, this court relies on the testimonies of its officers. Without evidence to the contrary, I'm inclined to trust Officer Davis's judgment. The fine for this violation is $150. Dr. Washington didn't flinch. She reached into her briefcase and pulled out a thin folder. Your Honor, I anticipated this, so I took the liberty of gathering some evidence. I have here photographs of the intersection taken at the same time of day as when I was cited, showing the visual obstruction. I also have statements from 2 witnesses who were walking their dog and saw me come to a complete stop. She handed the folder to the bailiff, who passed it to Judge Harrison. The judge flipped through the materials, his frown deepening. Dr. Washington, while I appreciate your thoroughness, this is a simple traffic court. We don't typically accept this kind of evidence without prior submission. Judge Harrison's courtroom fell into a tense silence as he examined the contents of Dr. Washington's folder. The photographs were undeniably clear. The elm tree did indeed create a significant blind spot at that particular intersection. The morning sun hit the leaves in such a way that dappled shadows played across the stop sign, making it difficult to see from certain angles. The statements from the dog-walking couple were handwritten but precise, noting the exact time and their clear view of Dr. Washington's vehicle coming to a complete stop. The evidence was compelling, but Judge Harrison's pride wouldn't allow him to immediately concede. He closed the folder slowly, buying himself time to formulate a response. The fluorescent lights hummed overhead as the air conditioning cycled on with a low rumble. The spectators in the gallery, mostly people waiting for their own cases to be called, had grown unusually attentive. This mundane traffic hearing had suddenly become the most interesting event in an otherwise routine morning docket. "Dr. Washington," Judge Harrison began, his voice taking on an edge of condescension that he often used when dealing with defendants who tried to challenge the system. "While I appreciate your thoroughness, this is a simple traffic court. We don't typically accept this kind of evidence without prior submission. The proper procedure would have been to file these materials with the clerk's office at least 3 business days before your hearing." He handed the folder back to the bailiff, who returned it to Dr. Washington. The judge's words hung in the air between them like a gauntlet thrown down. The few attorneys present in the courtroom exchanged knowing glances. The judge was on shaky legal ground, and they all knew it. Dr. Washington adjusted her glasses and received the folder with a steady hand. She didn't immediately open her briefcase to put it away, instead holding it as if she might need to reference it again momentarily. The corners of her mouth turned up ever so slightly, not in defiance, but rather in the manner of someone who had anticipated this very response. "Actually, Your Honor," she responded, her voice carrying clearly through the courtroom without needing to be raised. "According to State Procedural Code 15.7, defendants in traffic court are permitted to present exculpatory evidence at the time of hearing without prior submission requirements. This provision was specifically added to the code in 2018 to accommodate individuals who may not have legal representation or who may not be familiar with court filing procedures." The confidence with which she cited the code section caused Judge Harrison to pause. Most people who came through his traffic court had only a rudimentary understanding of the law, if any at all. They certainly didn't cite specific procedural codes with such precision. The court clerk, Miss Jenkins, a veteran of the judicial system with 25 years of experience, glanced up from her computer. She gave a nearly imperceptible nod, confirming that Dr. Washington's citation was accurate. Judge Harrison caught this out of the corner of his eye, and it only served to increase his discomfort. "I see," Judge Harrison replied, his tone shifting slightly. The woman before him was clearly educated, possibly even in the legal field. "And are you familiar with our procedural codes through your work, Dr. Washington?" Dr. Washington set the folder down on the defendant's table, her movements deliberate and unhurried. "Yes, Your Honor. I make it a point to stay current with all relevant legal statutes and procedural rules as they pertain to civil matters in our state." Judge Harrison's curiosity was now fully piqued. The bailiff shifted his weight from one foot to the other, sensing the unusual direction this hearing was taking. Usually, traffic violations were processed in less than 5 minutes. Guilty plea, fine assessed, next case. This interaction had already exceeded the typical time frame, and the judge's calendar was packed with dozens more cases before lunch. "Are you an attorney, Dr. Washington?" Judge Harrison asked directly, leaning forward slightly from his elevated bench. A subtle transformation came over Dr. Washington's face. The polite deference she had maintained thus far gave way to something more, a quiet confidence that seemed to expand her presence in the room. She stood a bit straighter, her shoulders back, and met the judge's gaze directly. "No, Your Honor. I'm a professor of law at State University. I teach constitutional law and civil procedure. I've been on the faculty for 23 years. The impact of her words was immediate. A murmur rippled through the courtroom. One of the attorneys waiting for their case to be called let out a low whistle, quickly stifled. The clerk's fingers hovered motionless above her keyboard for the first time that morning. Judge Harrison felt a cold sensation spread through his chest as recognition began to dawn. State University was where he had attended law school 15 years ago. His mind raced back through his student days, through lecture halls and study groups, through late nights in the law library and anxiety-filled exam periods. There had been a Professor Washington, a formidable, brilliant woman whose civil procedure class had been notoriously demanding. She had a reputation for calling on students without warning and expecting them to analyze complex legal scenarios on the spot. Her exams were legendary for their difficulty, but those who survived her courses often credited her with teaching them how to think like true lawyers. The judge's expression froze as memories clicked into place. The challenging professor who had pushed him harder than any other, who had once kept him after class to tell him he needed to be more thorough in his case analyses. That same professor who had written on his final paper, "Mr. Harrison, you have potential, but your arguments lack precision. The law demands attention to detail." "Professor Washington," he asked, his voice suddenly less certain, the authoritative timbre giving way to something almost resembling the tone of a former student. A moment of perfect silence filled the courtroom. Even the usual shuffling of papers and clearing of throats ceased. Everyone present sensed that something significant was unfolding. "Yes, Judge Harrison," she replied with a gentle nod of acknowledgement. "I thought I recognized you when I came in, but I wasn't entirely sure until you began speaking. You were in my civil procedure class in 2010, if I'm not mistaken. Third row, slightly to the left. You asked some insightful questions about Pennoyer v. Neff, as I recall." The specificity of her recollection struck Judge Harrison like a physical blow. That she would remember such details about one student among thousands she had taught over the decades was remarkable. But then, Professor Washington had always been known for her exceptional memory and attention to detail. The power dynamic in the courtroom had shifted perceptibly. Though Judge Harrison still sat elevated on the bench, robed in the literal and figurative trappings of judicial authority, he suddenly felt like he was back in her classroom, a nervous second-year law student hoping not to be caught unprepared. A flush crept up from beneath his judicial collar, spreading slowly across his face. It wasn't just embarrassment at the role reversal. It was the dawning realization that he had very nearly dismissed valid evidence and imposed an unjust fine on a woman who had once taught him the very principles of judicial fairness he was now sworn to uphold. "You always did prepare meticulously for every argument," he said after a moment, a hint of reluctant admiration in his voice. "I remember your emphasis on thorough research and attention to precedent." A few of the attorneys in the gallery exchanged knowing glances. This was not something they witnessed every day. A judge acknowledging his own past as a student, and by extension, his potential fallibility. Professor Washington's expression remained measured, neither gloating in this unexpected advantage, nor showing discomfort at the unusual situation. "Thank you, Judge Harrison. Those principles continue to guide my teaching. Every semester, I tell my students that the practice of law is fundamentally about preparation and precision." The bailiff, who had been standing at attention throughout this exchange, glanced at the wall clock. The morning docket was falling behind schedule, but he knew better than to try to rush the judge, especially in this particular situation. Judge Harrison cleared his throat and straightened his robe, attempting to regain some semblance of his judicial composure. He was acutely aware of the eyes upon him. The clerk, the bailiff, the waiting attorneys, the other defendants. This was a moment that would likely be recounted in courthouse corridors for years to come. "Well, Professor," he said, deliberately using her academic title rather than the more standard Dr. Washington or Ma'am he would typically use for a defendant, "your preparation today has certainly been thorough. These photographs clearly show the visual obstruction at the intersection, and the witness statements corroborate your account." He paused, weighing his options. He could still assert his authority, find some procedural reason to discount her evidence, and uphold the ticket. It would be within his power to do so. But what message would that send? What would it reveal about his character and his respect for the legal principles she had once taught him? The courtroom remained silent, collectively holding its breath for his decision. The morning sun had shifted during their exchange, and now a beam of light fell directly across the bench, illuminating the judge's face as if under a spotlight. Judge Harrison looked down at the citation form on his desk, then back up at Professor Washington. Their eyes met across the courtroom. Teacher and former student, now ostensibly adversaries in this minor legal proceeding that had taken on far greater significance than anyone could have anticipated. In light of the evidence presented, and the thorough nature of the defendant's case, he finally said, his voice finding its judicial certainty again, I'm dismissing the citation. Case closed. The gavel came down with a sharp crack that seemed to release the tension in the room. Professor Washington nodded, neither triumphant nor relieved, simply acknowledging the decision with the same composure she had maintained throughout. "Thank you, Your Honor," she said, beginning to gather her materials and return them to her briefcase. As she organized her papers, Judge Harrison made a quick decision. "Professor Washington," he called out, stopping her before she could turn to leave, "would you mind staying for a moment after we conclude the morning docket? I'd appreciate a brief word." Professor Washington looked up, her expression thoughtful as she considered the request. After a moment, she nodded. "Certainly, Judge Harrison. I'll wait." With that exchange completed, Judge Harrison turned his attention back to the court calendar, calling for the next case with a renewed attention to detail that hadn't been present earlier in the morning. The routine of traffic court resumed, but something had changed in the atmosphere of the room. The judge sat a little straighter, listened a little more carefully, and weighed the evidence presented in each subsequent case with noticeably more consideration. In the gallery, Professor Washington took a seat, opening a leather-bound planner and making notes, occasionally glancing up to observe her former student now administering the justice she had once taught him to respect. The morning sunlight continued its slow journey across the courtroom floor, highlighting dust motes that danced in the air like the shifting power dynamics that had just transpired before all present. The courtroom had emptied completely. The afternoon sun cast long shadows across the polished floor, transforming the austere space into something more intimate. Judge Michael Harrison had removed his black robe, draping it carefully over his chair behind the bench. Without it, he seemed somehow smaller, more human. He straightened his tie and ran a hand through his slightly thinning hair before descending the steps from the bench to the main floor of the courtroom. Dr. Eleanor Washington sat patiently in the front row of the gallery, her leather briefcase resting beside her. She'd been reviewing student papers while waiting, red pen making occasional marks on the margins. When she noticed Judge Harrison approaching, she capped her pen and returned the papers to her bag. Her movements were unhurried, deliberate, the same methodical approach she brought to her teaching and, evidently, to her defense in traffic court. "Thank you for waiting, Professor," Judge Harrison said, gesturing to the empty seat beside her. "May I?" "Of course," she replied, sliding her bag to make room. The formality of the courtroom proceeding had dissolved, but a certain tension lingered between them. Not hostility, but the complex dynamic of a former student who had risen to a position of authority, now facing his one-time mentor in unexpected circumstances. Judge Harrison sat down, leaving a respectful distance between them. For a moment, neither spoke. The only sound was the distant hum of the building's ventilation system and the muffled voices of people in the hallway outside. "Professor Washington," he finally began, turning slightly to face her, "I want to apologize for my dismissive attitude earlier. I should have examined the evidence more carefully before rushing to judgment." She studied him thoughtfully, her eyes taking in the changes 15 years had wrought on her former student. The eager, sometimes overconfident law student had been replaced by a man wearing the weight of daily judgment on his shoulders. Fine lines had formed at the corners of his eyes and mouth, some from smiling, others perhaps from frowning down from the bench. "Judge Harrison," she said, her voice carrying the same measured cadence that had guided countless students through the complexities of constitutional law, "do you remember the final paper you wrote for my class? It was on implicit bias in judicial decision-making." Harrison winced visibly, the memory clearly uncomfortable. "I do. You gave me a B- and wrote that I'd missed the point entirely." He paused, shaking his head with a rueful smile. "You said I'd focused too much on the theoretical framework and not enough on the practical implications for day-to-day courtroom decisions." Dr. Washington nodded, a flicker of approval crossing her face at his accurate recollection. "I'm impressed you remember my feedback so precisely." "It wasn't the kind of critique one forgets easily," Harrison admitted, "especially since I've been accustomed to as in most of my courses." A brief, knowing smile touched Dr. Washington's lips. And yet here you are, a judge yourself, she observed. I've followed your career, you know. You've made some thoughtful rulings over the years. That case involving the homeless encampment last winter, your opinion showed considerable empathy while still maintaining the rule of law. I assigned it as reading material in my advanced constitutional law seminar. Surprise registered on Harrison's face, followed by a flush of pride that he quickly attempted to mask. That was a difficult case, he said. The city wanted them removed immediately, but with the record cold temperatures, I couldn't in good conscience issue the order without ensuring adequate alternative shelter was available. It was the right decision, she affirmed. But today, I wonder if you might have fallen into the very trap you wrote about back then. The words hung between them, not accusatory but challenging in the way her questions in class had always been. Invitations to deeper thought rather than indictments of character. Harrison shifted in his seat, unconsciously straightening his posture as if he were back in her classroom. I'd like to think I'm fair to everyone who comes into my courtroom, he finally said, but his voice lacked conviction. The events of the morning had forced him to question his own objectivity in a way that was both uncomfortable and necessary. I'm sure you intend to be, Dr. Washington replied, her tone gentle but unwavering. But intention and impact are often different things. Did you know that black drivers are 3 times more likely to have their evidence questioned in traffic court than white drivers in this county? Harrison blinked, genuinely surprised. No, I wasn't aware of that statistic, he admitted. Is that from a recent study? It's from my own research, she explained. I've been collecting data for the past 2 years as part of a broader study on racial disparities in the lower courts. Most people focus on criminal sentencing at the felony level, but these everyday interactions in traffic and municipal courts actually touch far more lives. She reached into her briefcase and pulled out a slim folder, different from the one she had presented during the hearing. Here's a preliminary draft of the paper. It hasn't been published yet, but I'd value your perspective, especially since you're directly engaged with these issues daily. Harrison accepted the folder, a mixture of professional curiosity and personal discomfort evident in his expression. I don't keep track of demographics in traffic violations, he said, his brow furrowing. We process hundreds of cases a week. I treat them all the same. Do you? Dr. Washington asked, the question hanging in the air without judgment. When you saw me this morning, before you recognized me as your former professor, what assumptions came to mind? The question landed like a stone in still water, sending ripples of discomfort through Harrison. He opened his mouth to offer a quick denial, then closed it again. After a long moment, he spoke with unexpected candor. I assumed you were exaggerating about stopping completely, he admitted. And when you mentioned teaching at the university, I thought perhaps you were trying to use your position to influence the outcome. He paused, the realization of his own biases coming into sharper focus. I didn't give your evidence the same weight I might have given to someone else's. Dr. Washington nodded, not in triumph, but in acknowledgement of his honesty. Self-awareness is the first step, Judge Harrison. We all carry these biases. They're part of the cultural air we breathe. The question is whether we recognize them and work to counteract their influence on our decisions. A contemplative silence fell between them. Through the tall windows, the afternoon light had taken on the golden quality of approaching evening. Judge Harrison looked down at the folder in his hands, then back at his former professor. You're still teaching, he said with a small smile, and I'm still learning, apparently. Always, she replied. That's the beauty of the law. It's a living thing, constantly evolving. And so must we. She extended her hand, and he shook it firmly, the gesture marking a transition from the formality of their courtroom encounter to something approaching collegiality. My office hours are Tuesdays and Thursdays, 2 to 4, she added, rising from her seat and collecting her belongings. I'm currently working on a judicial education program about recognizing and mitigating implicit bias in the courtroom. I could use some input from sitting judges, especially those who come with both practical experience and a theoretical background in the issue, however rusty that might be. The last words were delivered with a hint of the wry humor that her best students had always appreciated. Harrison stood as well, surprised by the invitation and intrigued by the possibility it represented. Not just professional collaboration, but perhaps a chance to revisit the academic idealism that had led him to law school in the first place, before the daily grind of the courtroom had narrowed his vision. "I'd be interested in hearing more about that," he said, his tone reflecting genuine curiosity rather than mere politeness. "Perhaps I could contribute a case study or two from my own docket. Anonymized, of course." "That would be valuable," Dr. Washington agreed. "Real-world examples are often more instructive than theoretical scenarios." They walked together toward the courtroom doors, their footsteps echoing in the empty space. As they reached the threshold, Dr. Washington paused, turning back to Judge Harrison with one final observation. "And Judge Harrison, that stop sign really is partially obscured by that elm tree. You might want to recommend the city trim those branches before someone gets hurt at that intersection." With that practical note, the professor departed, leaving Judge Michael Harrison standing in the doorway of his courtroom, the folder of research in his hands, and a renewed awareness of the responsibility he carried each time he donned his judicial robe. He watched her walk confidently down the hallway, her posture as straight and dignified as it had been when she stood at the lectern of his law school classroom years ago. Harrison turned back to look at his empty courtroom, seeing it suddenly through new eyes, not just as a venue for processing cases, but as a space where lives were shaped, where justice was either served or denied, and where his own biases, however unconscious, influenced outcomes that affected real people. The realization was both humbling and empowering. He returned to his chambers, set Dr. Washington's research on his desk, and made a note to contact the city about that elm tree first thing in the morning. 2 weeks had passed since the memorable traffic court hearing. Judge Michael Harrison sat in his office, morning light filtering through the blinds and casting striped shadows across his desk. Before him lay Dr. Washington's research paper, dog-eared and marked with sticky notes. He had read it 3 times now, each reading revealing layers he had missed before. The statistics were irrefutable, meticulously gathered and analyzed. In their cold precision, they told a story of systemic inequity that played out daily in courtrooms like his across the country, a story he had been part of without fully recognizing his role. Harrison rubbed his eyes, feeling the weight of accumulated decisions over his years on the bench. How many Eleanor Washingtons had stood before him, their evidence dismissed too quickly, their arguments given less weight than they deserved. The question haunted him. It was not that he considered himself prejudiced. Quite the opposite. He had always prided himself on his objectivity, his commitment to blind justice. But Dr. Washington's research suggested that neutrality was not enough, that the absence of intentional bias did not guarantee the presence of fairness. The intercom on his desk buzzed softly. "Judge Harrison," his assistant's voice announced, "your 10 o'clock appointment is here. Dr. Washington from the university." "Send her in, please," Harrison replied, standing and straightening his tie. He had traded his judicial robes for a charcoal suit today. This meeting was not court business, but a first step toward something that felt more significant than any ruling he had issued in recent memory. Dr. Washington entered, carrying her familiar leather briefcase. She wore a deep burgundy blazer over a cream blouse, her silver-streaked hair arranged in a neat twist rather than the bun she had worn in court. "Judge Harrison." She greeted him with a warm but professional smile. "Thank you for making time in your schedule." "Please call me Michael," he offered, gesturing to the chair across from his desk. "At least when we're not in court. And thank you for sharing your research. It's been illuminating." Dr. Washington sat, placing her briefcase on the floor beside her. "I'm glad you found it valuable. And you're welcome to call me Eleanor, though I suspect old habits die hard. Most of my former students still call me Professor Washington even decades after graduation." A small smile crossed Harrison's face. "I'm not sure I could call you Eleanor without feeling like I'm about to be called on to brief a case I haven't adequately prepared for." They shared a moment of genuine laughter, breaking the last vestiges of formality between them. The morning sun had shifted, illuminating a wall of photographs behind Harrison's desk: his law school graduation, his judicial investiture, community awards, and family pictures. A visual timeline of a life dedicated to the law. "I've been thinking about what you said," Harrison began, leaning forward slightly. "About intention versus impact. I've always believed that treating everyone exactly the same was the definition of fairness. But your research suggests that's not enough." Dr. Washington nodded thoughtfully. "Formal equality often preserves existing inequalities. Think of it this way. If we have two runners, but one starts 50 yards behind the other, treating them exactly the same during the race doesn't make the competition fair. The initial disadvantage remains unaddressed. And in my courtroom. In your courtroom, the defendants don't all start from the same place," she explained. "Some have attorneys, others don't. Some understand the system and speak its language fluently. Others are navigating it for the first time. Some have been conditioned to expect fairness from institutions. Others have learned through hard experience to expect the opposite." Harrison rose and walked to the window, looking out over the courthouse square below. Citizens moved about their business, entering and exiting the various municipal buildings, most unaware of how the decisions made within these walls shaped their lives in countless ways. "Since our encounter," he said without turning, "I've started keeping track. Nothing official, just personal notes. The disparities are difficult to ignore once you start looking for them. I've noticed patterns in how I respond to different defendants, in the benefit of the doubt I extend or withhold." He turned back to face her. "It's uncomfortable, to say the least." "Growth usually is," Dr. Washington replied simply. "The question is what you intend to do with this awareness." Harrison returned to his desk, pulling a folder from the top drawer. "I've drafted a proposal for our judicial district. A blind review process for traffic citations. Officers' reports would be standardized, and identifying information about defendants would be redacted during initial review." He passed the folder to her. "It's just a start, but it might help eliminate some of the unconscious biases affecting these decisions." Dr. Washington accepted the folder, genuine surprise registering on her face. She opened it and scanned the contents, nodding with growing approval. "This is more than I expected, Judge. Michael, this could make a real difference." "It's not just about traffic court," Harrison continued, a new energy in his voice. "I've also spoken with the chief judge about incorporating your judicial education program into our mandatory continuing education curriculum. She's interested in having you present at our next quarterly conference." Dr. Washington closed the folder, visibly moved by the unexpected development. That would be an incredible opportunity. The lower courts are where most citizens encounter the justice system. Meaningful change at this level could restore trust in ways that high-profile Supreme Court decisions never could. Harrison leaned back in his chair. "You know, I still have that B- paper you eviscerated 15 years ago. I keep it in a box with my law school memorabilia. At the time, I thought you were being unnecessarily harsh. Now I realize you saw potential I wasn't living up to." "I only push students I believe in," Dr. Washington said with a gentle smile. "The truly mediocre ones get polite comments and a C+." They shared another laugh, the mentor-student dynamic evolving into something approaching friendship, built on mutual respect and a shared commitment to justice that transcended their different perspectives and experiences. "There's one more thing," Harrison added, reaching for his phone. "I called the City Works Department the day after our court hearing. They sent a crew out to trim those elm branches at the Maple Street intersection." He turned the phone to show her a photo of the clearly visible stop sign, no longer obscured by foliage. Dr. Washington's eyes crinkled with appreciation. "Sometimes justice is about the big systemic changes," she said, "and sometimes it's about making sure everyone can see the stop signs." The symbolism wasn't lost on either of them. In many ways, Dr. Washington had been that stop sign for Harrison, forcing him to pause, to reflect, to reconsider the path he was on before proceeding. "I've reserved a conference room downstairs," Harrison said, standing up. "I invited a few colleagues who might be particularly interested in your research, judges from neighboring districts, our county's public defender, even the district attorney. I hope you don't mind. I thought it might be valuable to start the conversation with a small group before the quarterly conference." Dr. Washington rose as well, gathering her materials. "I'd be delighted. Though I should warn you, some of my findings might make for uncomfortable discussions among your colleagues." "I'm counting on it," Harrison replied with newfound conviction. Comfort rarely leads to change. As they walked together toward the conference room, their footsteps echoing in the marble hallway, a young black woman approached from the opposite direction. She carried a stack of files and wore the anxious expression of someone new to the courthouse environment. "Good morning, Judge Harrison," she said hesitantly. "Good morning, Miss Taylor," he replied warmly. "Dr. Washington, this is Amara Taylor, our newest law clerk. She just joined us from State University Law School, as a matter of fact. Graduated top of her class." Dr. Washington extended her hand. "It's a pleasure to meet you, Miss Taylor. I believe you took my constitutional law seminar last year. Your paper on equal protection jurisprudence was exceptional." The young woman's face lit up with recognition and surprise. "Professor Washington, I had no idea you knew Judge Harrison." "We go way back," Dr. Washington replied with a meaningful glance at Harrison. "The judge was once in your shoes, though perhaps not quite at the top of his class." Harrison laughed genuinely. "Definitely not. But I'd like to think I've been a good student since then." He gestured toward the conference room doors. "Miss Taylor, would you care to join us? I think you might find this discussion particularly relevant to your work here." As the three of them entered the conference room, where several other legal professionals awaited, Harrison felt a sense of purpose that had been missing from his work for longer than he cared to admit. Today was not about processing cases or clearing a docket. Today was about beginning a conversation that might, in some small way, bring the reality of justice closer to its ideal. The lesson that had begun in traffic court with a simple stop sign violation had evolved into something far more significant, a reminder that justice required continuous learning, humility, and the courage to examine one's own biases, even when that examination was uncomfortable. And as Judge Michael Harrison took his seat beside his former professor, ready to introduce her to his colleagues, he recognized that some of the most important lessons in law came long after law school had ended.